Thank you very much, Andrew. Pleasure to be here, and we're very excited to be able to deliver the mock trial for you. The way it's going to work is I'll run through very briefly a bit of background to the mock trial and explain why it's relevant. I'll then introduce the parties who we have involved, and then I'll call the matter, and it's going to run as close to a real court proceeding as we can get. So we'll follow the formalities as best we can. So as many of you, if not all of you, are aware, Chronic Traumatic Encephalopathy, which, having pronounced it successfully once, I'm going to refer to as CTE going forward, is obviously it's an emerging area of risk, an emerging area of liability law throughout the world and in Australia. And it's also it's an area of interest in the scientific and research community, as the understanding of the CTE as an injury and its causes and what its impacts continue to be understood. From a liability perspective, the claims, this is not something that is so far in the future that it's off the radar. In 2015, the NFL in the US settled a class action. As of today, or fairly recently, it's paid out over $1.2 billion US towards people who claim to have suffered CTE and who have developed dementia and other brain injuries as a result. In 2023, there were 2 claims brought against the National Collegiate Athletic Association, the NCAA, in the US. Both of them were defended successfully for various reasons, but to give you an idea, the headline claim in one of those matters was $55 million. There's a claim in the UK, a class action being brought by rugby players or former rugby players. Closer to home, there are 2 class actions that have been commenced in the Victorian Supreme Court by current and former AFL players. The size of the class in one of those class actions are people who played professional AFL from 1985 to 2023 and had suffered a concussion. So you're getting an idea of the extent of these claims and their potential quantum. In December 2023, the Victorian State Coroner published his findings in the inquest of the death of a former AFL footballer, Shane Tuck, and in that made a number of recommendations about procedures, guidelines and protocols that should be followed by the AFL. We've had a National Senate inquiry in September 2023 that looked at the issue and delivered findings and considered what address was available through the courts for people who have suffered. So that's the landscape, that's the broader context. What are we dealing with here today? And just to clarify, all of this is made up, and the people here, although they're actual practicing lawyers and actual leading experts in the field, are role-playing. So what they say doesn't necessarily represent their views or even their opinions on certain matters, because we've done this to suit the facts. But what we're dealing with is a unfortunate case of James Jimmy Davison. He was a promising rugby union player from an early age, played for the North Parramatta Lions in Sydney from age 10. He was so good that at the fullback position that he earned a scholarship from year 7 to a prestigious high school in Sydney and played rugby for that high school all the way through to year 12. He continued on playing rugby union when he went to Coogee University, and he played for their club, which was called the Backpackers. That was set up as an affiliated association with the university. Throughout his career, through his rugby career, through school, before school, high school and university, he suffered a number of concussions, which we'll unpack as we move through the evidence. In his final year of university, he had 2 very bad concussions, and he was effectively advised by his neurologist that he had to give up rugby. That was in 2010. So 15 years later, his life's become quite dire. He's been diagnosed with dementia. He is suffering mental health issues and depression. He struggles to hold down a job, and his motor skills and memory are in significant decline. So what he has done is he has brought a claim against Coogee University, against the Backpackers, and against his high school, alleging that the condition he suffers is CTE, and that they are responsible for that. So that's the facts that we have in front of us. The parties, the people who are going to deliver the mock trial, Simon Iliff from Unimutual has very kindly agreed to be James Jimmy Davison. We have his barrister, Audrey Bosman from Nyland Chambers in Adelaide. We have Steve Connell, a principal of Gilchrist Connell in Sydney, and that is his actual last name. I didn't get that wrong with the firm. And we have John Edmund, who is the chairman of Gilchrist Connell, who is going to be the presiding judge today. On the screen, or on the screen, we have Dr. Rowena Mobbs. I'll just make sure. Dr. Rowena Mobbs is a visiting medical officer and neurologist at Mater Hospital, one of Australia's leading clinicians in concussion and dementia. She's the founder and director of the Australian CTE Biobank and created an online education program called Concussion Big Five for detecting common neurological signs of concussion. We also have Dr. Adrian Cohen, who is an expert in emergency medicine and trauma, and is the innovator of several medical concepts, including NeuroCheck, HeadSafe and NeckSafe. And they will be giving expert evidence today on the issue of whether CTE can be diagnosed and other issues relating to Mr. Davison's injuries. So without further ado, I think I've covered off all of the housekeeping matters. Unlike real court, you will have an opportunity for questions at the end that you can ask the judge or anybody else. But if you could hold your questions to the end, that would be much appreciated. Otherwise, I call the matter.
You want to mention that it's the application for strikeout as well, rather than...
Yes.
That's probably fine.
Yeah, absolutely. So the context of this is we're dealing with two matters that are relevant to the dispute. We're dealing with an application for strikeout for the pleadings. In relation to, there's really two matters. The first is whether CTE can be diagnosed while Mr. Davison is alive, which is an area of medical causation. And the second issue is whether the university can rely on a particular part of its defence that relates to waivers and consent forms it says Mr. Davison signed. Unfortunately, nobody can find those forms. And they've not been able to be, there's no evidence on at the moment that they exist, I believe. But that will all be unpacked. The reason we're focusing on these two issues are, if this was a hearing proper on all of the issues you might consider, would all be here for weeks or months, moving through those issues. So without further ado, I call the matter of Davison and Coogee University and others.
Thank you. Appearances. So, Mr. Connell, who do you represent?
Your Honour, my name is Connell. I appear for the applicant, which is also the defendant, University of Coogee.
Thank you. And Ms. Bosboom.
May it please the Court, my name is Bosboom and I appear for the applicant in the overall proceedings, Mr. Davison.
Excellent. Thank you. And I understand Mr. Davison's here today. He should be giving evidence at some point. Is that right? Yes, good. Thank you. Well, it would be good if we could start with an outline of submissions, please, Mr. Connell.
Thank you, Your Honour. Yes, as I said, I act for the Coogee University, which is, Your Honour will know, is a very pleasant, lovely university situated on the beach south of Sydney. A lovely place to study and to play rugby for the Associated Backpackers Rugby Club. It's the sort of university Your Honour would have enjoyed studying at, playing sport at, if you'd ever qualified for entry there. But that's just a side. Before Your Honour is my client's application for summary dismissal of the plaintiff's claim. And his claim is that he suffered CTE as a result of head knocks sustained in his 4-year career at the Backpackers. Now, I understand that it's a very high bar, as Your Honour knows, that I will have to get across. A very difficult task for me to persuade Your Honour that you should summarily dismiss this claim, because I will need to persuade you that the case has no possible prospect of success. But I expect that after Your Honour has heard the evidence and my submissions, you'll have no difficulty in acceding to my application. So I'll start by just addressing a few opening remarks to Your Honour and to ladies and gentlemen of the jury. We don't usually have a jury in these cases, but it's very lovely and it's nice to have all this group of intelligent people to assist His Honour in what is going to be, no doubt, a very complex and difficult case. So There are a lot of legal issues, and we're not going to dwell on them, but I'll just outline them just so that we put it in context. So this case is governed by the laws of New South Wales, because that's where the accident or the series of incidents happened. And in New South Wales, there is the Civil Liability Act, which governs these sorts of claims. There's similar legislation, slight variations in other states, but so we're dealing with the New South Wales Civil Liability Act, and there are a lot of defences in that act to these types of claims. So there is the defence of obvious risk, which is Section 5F of the CLA. So that's a risk that would have been obvious to a reasonable person in the position of the plaintiff. And in that case, there's no proactive duty on the part of the defendant to warn the plaintiff of an obvious risk. Second defence is one called inherent risk, which means that there is no liability for harm suffered by the materialisation of an inherent risk of harm, and that means something that cannot be avoided by the exercise of reasonable care. There's a defence called the dangerous recreational liability defence. That's Section 5M of the Civil Liability Act, which says there's no duty of care owed to a person who engages in a dangerous recreational activity. We have another issue about the possible contractual waiver of liability. That is that the plaintiff signed a waiver and therefore a contract saying that he won't hold the organisation liable. And again, the Civil Liability Act says that that type of contract is enforceable in New South Wales.
You'll be able to show me, you'll be able to take me to those.
I'll take Your Honour to the relevant evidence in due course.
Thank you, Mr. Con. Thank you.
We don't have a document. Your Honour will understand the difficulties of, a case this old. It's over 15 years since he's played his last game of rugby, and sometimes documents disappear, but I'll have some evidence and some witnesses that Your Honour will be very impressed by.
Thank you, Mr. Con.
There are possible time limitation issues. As I said, it's 15 years since his last game of rugby, and there are time limitation problems for him. And then there are big issues of causation. So, Mr. Davison, his case is that he has suffered head knocks since he was 9 years of age, playing for the North Parramatta Lions, and multiple head knocks over many years of playing rugby for a number of different clubs, the Parramatta Lions, his school, Princess High School, and lastly with the Coogee Backpackers. So, when did it start? When did it end? What are where's the causal potency with all these different head knocks, and who's going to be responsible? Of remembering that I'm just acting for the university here, not for the school or the Parramatta Lions. So there's those issues of causation. There are medical issues. And then there are all the issues of to do with negligence, which is foreseeability, the duty of care, the standard of care, and a lot of that will turn on what was known by relevant people at the relevant time, what was known generally in the community, what the different organisations should have known, what reasonable steps they should have taken, whether those reasonable steps would have made any difference in Mr. Davison's case, and what each of those organisations actually did. So, you see, ladies and gentlemen, this is a very big case. There are many, many issues. It's going to take us 3 months to finish. But I understand that His Honour has some other commitments, and I understand also that some of you want to have a drink at 4:30. So we're going to finish this case in 1 hour, and so I'll stop talking and let my friend address her remarks.
Thank you, Ms. Bosman.
Thank you, Your Honour. In my submission, it is up to my friend to establish a reasonable basis to seek summary dismissal of this matter. And as he touched upon, that is a very high bar. In the circumstances, I'd say that he should be put to proof on those matters, and I don't propose to address Your Honour further at this time on that issue. Rather, if I can take Your Honour to my client's application pursuant to Rule 70.31B of the Uniform Civil Rules, which do apply here in South Australia, although the substantive law of New South Wales will apply to the main claim. Our rules apply to this strikeout application. It relates to paragraphs 34 and 35 of the defence, which rely upon consent and waiver forms allegedly signed by the applicant when he was playing rugby. That's paragraph 34. And then paragraph 35 refers to particular protocols that were put in place and medical staff that were engaged by the rugby club to guard against head injuries. However, the difficulty in my submission, Your Honour, is that following discovery of all relevant documents, the backpackers have had to concede that they can't produce any relevant consent or waiver forms provided or signed by my client. They can't locate or obtain any witnesses who can say that they were involved in the administration of the rugby club at the relevant time to verify the forms that were in existence. They can't produce written protocols or anyone who can give evidence about the protocols, and they can't identify which organisation they went through to engage the medics. So, Your Honour, that is the background to my client's application, and after Your Honour has heard the evidence, I will make submissions as to why, based on that evidence, paragraphs 34 and 35 of the defence should be struck out.
Thank you, Ms Bosman. Understood. That makes sense.
Now, somewhat unusually, Your Honour, I understand that you wanted to hear from my client in relation to the summary dismissal application.
Yes, this is a particularly unusual case in the time available, so we'll probably
it is a bit unusual.
Rush the witness in.
But I have made my client available for today, so I call Mr Davison.
Please, Mr Davison, make yourself comfortable and have some water. There's still all sparkling here in this court.
Now, Your Honour, I understand that Mr Davison has already been sworn in.
Yes, I think he was sworn in outside in the foyer.
Thank you.
You remain under oath, Mr Davison.
Yes, Your Honour.
Thank you.
Mr Davison, would you please state your full name and date of birth?
Mr Davison, did you?
Jimmy Davison. James Davison. I was born on the 23rd of June, 1988.
And do you prefer James or Jimmy?
Jimmy's good.
Now, Mr Davison, you have sworn an affidavit in these proceedings, is that correct?
Yes,
And that document is the one in front of you?
I believe so.
Well, can I ask you to check it closely, Mr Davison? Is that the affidavit you swore in these proceedings on the 5th of February 2025?
Sorry, yes it is.
All right. No need to apologise, Mr Davison. Your Honour, I'd like to read that affidavit of Mr Davison dated the 5th of February 2025. Take that as read.
Thank you, yes.
There are no objections from my friend, I understand. Mr Davison, when did you start playing rugby union?
Oh, when I was a really young bloke. Maybe the late 90s. I was a junior at the North Parramatta Lions. I think Mum's got some photos of me playing my first games when I was around 10.
And how would you describe your rugby ability at that age?
Oh, I wasn't too shabby. I was pretty good.
What position did you play?
Fullback.
And how did you get along with your coaches?
Oh, I liked my coaches. They were all good fellas. We were all there to have fun, of course. They kind of liked me. I could catch the ball. Didn't drop it much.
And where did you go to high school, Mr Davison?
Prince's College in Sydney.
And can you describe for everyone what kind of high school Prince's College is?
Oh, it's one of the top schools in Sydney. I only got to go there because I got a scholarship from year 7 through to year 12. Otherwise, Mum and Dad could never have afforded to send me there.
And how did you get that scholarship? What was it for?
Playing rugby, of course.
And was it a requirement of the scholarship that you play rugby for the school?
Yes.
What level of rugby did you play?
I played the top level for my age group throughout school, other than when I was in year 11 and 12, and I played for the first 15 in both years and was captain of the first 15 in my final year.
And that was 2006?
Correct.
And where did you go after high school?
I went to Coogee University to study a Bachelor of Economics. I got a scholarship to uni as well, so I didn't have to pay for that either.
And what was that scholarship for?
I had to play for the university team, the Backpackers.
The Backpackers, all right. How were they related to the university?
Oh, I think they...
I think that's a fair objection, but I think it's not a matter of contention, as I understand it, that the Backpackers is simply the name of the university team. That's how I understand it. Please correct me if that's wrong. That's right? I think we can move on.
Thank you, Your Honour. I'll move on to the next question. How would you describe the Backpackers in terms of their competitiveness, Mr Davison?
They were a
strong team?
Very, very strong team, very competitive team. We were in the grand final, the finals of the grand final every year I was playing.
And how often did you need to train for the Backpackers?
2 or 3 times a week.
And what did training involve? Any tackling?
Oh, yeah, plenty of that. You got to train how you play.
When you say plenty of tackling, how often?
Oh, probably at least 15 minutes per session, if you averaged it out.
And would that tackling involve head knocks?
Oh, yes, all the time, I suppose. You can't help it when you get tackled.
So that was during training. How often did you play games for the Backpackers?
Oh, it was a 16-week season with 1 game per week. As fullback, I played all games unless I was injured, and I was hardly ever injured.
And training, how long did that run for? Was that 16 weeks or something else?
That went all the way through the season, and for a number of months before the season started, I was playing or training for 35 weeks a year.
So you've addressed tackling during training. What about tackling during games? Did you get tackled during games?
Well, of course I did. I was good, but I wasn't that good.
Mr Davison, I'd like you to turn your mind now to what you know about any injuries you might have suffered while you're playing rugby. When was the first time that you recall being concussed?
I think it was about in the year 2000. What would have been 12? I was playing for the Lions in a grand final and got tackled high after taking a Gary Owen.
And
Taking a what?
A Gary Owen, Your Honour.
What's a Gary Owen?
Oh, high ball.
Oh, thank you.
thank you, Your Honour, for clarifying that. I wasn't sure either. I assumed you might know.
Thank you.
How did you know you were concussed, Mr Davison?
Oh, I think afterwards, my mum asked if I was okay because I'd been stumbling around on my feet after I got up. I kind of shook it off. And we went on to win the grand final. And, of course, I scored the winning try.
So just mainly the stumbling around. And when was the next occasion where you recall a concussion?
Oh, I can't recall the exact time and date, but I suffered about 4 concussions when playing for the first 15 of my high school.
And when you say 4 concussions, how do you know that?
Oh, I know that I did because the school had a Medicaid Games and he was required to fill out paperwork if any player was injured. When I went to the school and requested my file, I found forms filled out by the medic that described me as being knocked out in 4 games. I can't remember those games exactly, but I generally remember that sometimes my mates at school would talk about the game.
Well, Your Honour, I've got to object here. This is hearsay evidence, obviously, that the witness is embarking upon. So he's got to tell a story.
That's fair. I think we can leave that to the documents, and I accept that objection.
Can I take you back to the forms, Mr. Davison?
Mm-hmm.
They confirmed the concussions, did they?
Yes.
And those forms are exhibited to your affidavit?
Yes.
And what was the next concussion you know of?
In June 2008.
And who were you playing for at the time?
It was when I was playing with the Backpackers.
And what happened?
I was spear tackled in a game, lost consciousness for about 5 minutes, and I was taken to the hospital from the ground.
How do you know that you lost consciousness?
It was televised, so I've got the footage. I also remember parts of the ambulance ride. I think I remember the green whistle and being in the hospital.
And how long after that did you commence training or playing rugby again?
I didn't train the following week or play the following weekend, but I was chomping at the bit to get back to playing as we were having a great season. So I was back training on the Monday following the first game I sat out.
So just to clarify, that was 1 week off?
Yes, 6 or 7 days.
Did anyone at the Backpackers or the university try to stop you from playing that soon after?
No, not really. I think the coach might have told me that I could have another week off if I wanted it, and that she should probably make me rest another week. He said to me, though, you know your body best, son. If you feel up to it, I won't hold you back. I didn't want to let the coach or my teammates down, so I just got on with it and kitted up.
And when's the next concussion that you recall or know of?
The next one was in 2010. I can't forget that one.
Why is that? What happened?
Well, it was my final year of uni, and I copped a coat hanger right around the neck by some big unit of a human on the other side, on the other team. Knocked me out cold, completely, and I was stretchered off the field.
To the hospital?
I didn't want to go back to the hospital.
Why not?
I came to and I was feeling okay on the sideline. Didn't want to have to be stuck in that hospital emergency room waiting again.
And did you suffer any more concussions after that?
Yes. Only 6 days later, I was back training for the Backpackers. I was tackled in the usual way, right? Nothing serious, but for some reason, it knocked me out cold again. That really scared me because I shouldn't have been knocked out from that kind of tackle. It's just a normal tackle, not even a hard one.
And what happened next, Mr. Davison?
Well, I stopped playing and training after that. I saw a doctor because I was worried about how easily I'd been knocked out, and they said I shouldn't play anymore. If I did play, I risked serious brain injury because of the number of serious concussions I've had, and it was devastating for me because rugby was such a huge part of my life. I also never knew before then that repeated concussions could result in me not being able to play again.
Have you played any rugby or other contact sports since then?
No, because it scared the blasted bejesus out of me, what the doctor said.
And aside from the concussions you've referred to already, are there any other times where you think you've suffered a brain injury, something less than a full concussion perhaps?
Oh, absolutely. There's footage of me getting knocked out when playing for the Backpackers and stumbling around afterwards because I'm disorientated. That was just part of playing, and I prided myself on being a tough rooster and being able to shake it off.
So you say knocked out. Were you knocked out or just knocked about?
Oh, not really. I take concussion to be losing consciousness completely. Getting a knock and being disorientated wouldn't be being concussed in my book.
And have you seen a neurologist or any other doctors about your concussions and head knocks?
Yes.
Why did you see a neurologist?
Well, first I saw my GP because I'd been experiencing memory loss and difficulty doing basic things that I used to be able to do. Pretty much everyday tasks that require coordination with my arms, hands and legs. So sometimes I just couldn't get my body to do them properly. I also find myself getting confused. When I explained this to the doctor, he referred me to a neurologist.
And what did the neurologist say?
He did heaps of scans and tests. He said I'm displaying early signs of dementia and that my motor skills and memory are declining significantly.
And Mr. Davison, can you explain to His Honour and the jury the symptoms that you're experiencing and how they affect your life?
Yes. Well, my life's a mess. I drink a lot now, much more than I ever used to. I'm always depressed. I struggle with my mental health. I find it hard to maintain relationships with friends or partners. I can't hold down a job because I'm always forgetting things and getting confused.
Thank you, Your Honour. I've got no further questions.
Thank you, Ms. Bosman. Mr. Davison, that's I'm very sorry to hear that. Particularly your evidence at the end of it about drinking a lot and having some depression issues. You should perhaps consider a job as a judge. But leaving that for a moment, I know you said you couldn't hold down a job, but this is a pretty easy one. Could I ask?
Your Honour, would rape mentor me?
Quite possibly. We'll take that offline. Mr. Connell, I'll be your witness. Would you, Mr. Connell's going to ask you some questions. You realise he represents Coogee University, and I'd ask you please to answer the questions as honestly and forthrightly as possible.
Yes, Your Honour.
Thank you, Your Honour. Yeah, just a few questions. Have you noticed how rugby players always wear a tie when they get into the witness box? So you've played rugby. Just ask me to repeat the questions if you forget what I've said. You've played rugby since you were 9?
Or 9 or 10.
Yeah. And you loved it? You loved the sport?
Oh, I love playing rugby.
And you were good at it? You were very good at it?
I wasn't too shabby.
No. No one ever forced you to play rugby?
No.
No. Okay, that's all right. And incidentally, do you remember the name of your first coach at the North Parramatta Lions?
Oh, gee. Macca.
Yeah. And what about your coach at school? Do you remember him?
Oh, Father Bob.
Sounds right. And at university, at the Backpackers, who was the coach of the Backpackers?
Big Nev.
Yep. No, I didn't think you'd forget that. And now, you've told us about your head injuries, and I think, how many concussions did you say you've had over your career?
I'd had a few.
Yeah. The first one was when you were in the final in the juniors at North Parramatta?
Oh, I think so. Weren't you listening?
Yes. Just want to see if you remember it. And then at school?
Yes.
And you know that because you read some forms later, and
yes,
your lawyers showed you some forms, and that's how you remember that.
Well, I think I remember other than that.
Did you ever wear headgear? When you were playing rugby?
I think they'd run out at Mick Simmons when Mum went to get me some. So no.
Okay. because they'd run out.
Yeah.
Okay. Anyone ever advise you to wear headgear?
Oh, I don't recall you.
Do you remember the protocol at the backpackers where if you were injured, they'd have a doctor check you out?
Yeah, and they give you an ice pack.
Yep.
Yeah.
Did you play other sport?
Uh,
Play cricket?
yes.
Yeah. Ever get knocked on the head at cricket?
No. Mate, I just cut it for 4.
Yeah.
Or hook it over the other side. Bowl me a bouncer any day.
And what about any other? You play AFL?
No.
No. Lacrosse?
No.
Boxing?
Oh, no.
Any other martial arts?
Taekwondo.
And what about kickboxing?
Taekwondo.
Taekwondo, yeah. And there's a bit of kicking and boxing and head bashing in that, isn't there?
No.
No?
It's very, very disciplined.
Okay. All right. What about other accidents? Did you ever fall out of a tree when you were a kid? Did you fall off your bike?
Only grazed knees from memory.
Never fell on your head?
Maybe when I was being born, but that would be about the only time.
Okay, well, we'll go back to your birth. No, we won't. And now you say you don't. Do you play any sport now? Tennis or bowls?
No, I just exercise my elbow these days.
So you have been exercising your elbow for a long time, haven't you? I think you told the doctors that you had a problem with alcohol and substance abuse when you were 17. Is that right?
Oh, I think alcohol, I don't know that I don't recall I mentioned substance abuse.
The doctors have referred to substance abuse in their reports. They said you gave them a history of. So has that helped you to jog your memory about what kind of substances they might have been?
Your Honour, I
To
object
answer
to
that question, Your Honour.
It's in the medical report.
It would help the court if you could remember if there's been any kind of substance.
Your Honour, I object to that question. The current evidence is that Mr Davison abuses alcohol. There is no suggestion that he currently abuses any other substances, and in my submission, any evidence that my friend is seeking to adduce in relation to that is irrelevant and prejudicial.
Well, I would submit that it is relevant, Your Honour, because a lot of the symptoms that Mr Davison's describing are symptoms that are commonly associated with mental health and alcohol and substance abuse causes, and so it would be helpful for Your Honour to know whether that has been a factor.
Thank you. Mr Connell, would you ask the question again, and I'll listen very clearly to Mr Davison's response.
So I'll rephrase it. Do you accept that you had an issue with substance abuse when you were 17 years of age?
Alcohol abuse? Yes.
And not substance abuse?
Not that I'm aware of.
Okay,
I think
right,
we can move on.
We'll move on from there. When did you start drinking alcohol?
Oh, I think after we won the grand final when I was 17.
Right, but you said you had a problem with with alcohol abuse at 17, so you must have been drinking before that.
Oh, maybe I drank too much the first time.
All right, well, we'll move on from there. Get to the point. Sorry. Okay. Yeah. So, no further questions, Your Honour. Thank you. Yeah.
Thank you very much, Mr Connell. And Mr Davison, your evidence has been extremely helpful today. I'm obliged to you. If you'd like to... sorry, no re-ex, I should ask. No, sorry, no re-examination. If you'd like to leave the courtroom, we'll continue with the proceedings, although for the purposes of today, you're welcome to
Thank you,
back
Your
over
Honour.
there. Thank you very much. Oh, there's a round of applause. And that was very nice of... well, it's good to hear from Mr Davison. I should say, born in 1988, he's had a hard life. Hard life. Now, where to now, Mr Connell? It's on your... We're going to go straight to medical evidence now, who've very kindly been waiting online for us. Thank you.
Yes, again, highly unusual to have the experts
Yes,
listen to
the experts wouldn't normally be listening to the evidence.
applicant's evidence. Now, I think they're both off mute.
Can I just check that you're both off mute? Dr. Mobbs and Dr. Cohen, I believe. Hello.
Hi there.
Hi. Can I start by asking you, Dr. Mobbs, what is CTE?
So CTE, chronic traumatic encephalopathy, is a form of dementia or neurodegeneration. So this is where neurons are gradually lost or die off in their connections. And it's due to repeated traumatic brain injury occurring even distant from that injury, so years after the sustained burden of traumatic brain injuries. We're talking about thousands of head knocks and traumatic injuries rather than singular head injuries. And it triggers off a tau protein, or tauopathy as we say, gradually affecting some areas of the sort of valleys of the brain, spreading to other areas gradually, like any dementia, and leading to cognitive and behavioural decline with emotional deficits, memory deficits, and across the board cognitive decline like any dementia, eventually associating with a gradual loss of function and sadly demise.
Thank you, Dr. Mobbs. I think you referred to tau protein just for the transcript. That's TAU?
Correct.
And Dr. Cohen, would you agree with that, or do you have anything else to add?
No, I agree with that. I think it's got accepted.
And how might you identify that someone has CTE?
So there's a process of clinically excluding causes or mimics of different dementia subtypes, for example, or mimics of those dementia subtypes, plus including criteria for a traumatic encephalopathy syndrome, as we say, the features of CTE during life. So on the exclusion side, we do MRI and FDG PET brain, excluding Alzheimer's, excluding frontotemporal dementia or other dementia subtypes, for example. We reasonably treat away any medical conditions mimicking dementia, and we see the picture of CTE in someone. So this is a decline over often several or many years, actually, of neurocognitive functioning with impairment on testing, such as neuropsychology testing, along with imaging features of dementia in a gradual decline and worsening pattern.
And sorry, I might have missed it, but is the clinical history important as well?
Indeed. So the examination includes that information on clinical history, not just from the patient, but what we call collateral history, so from the patient's family, as the patient may not have insight into their cognitive deficits and symptoms.
But that would also include the history of blows to the head, so contact sports and the like.
Indeed. So typically one would require at least 5 years of repeated blows to the head, at least 2 years at the higher level within that number. And we see an accelerated, increased rate of CTE in those who have had at least 10 years exposure, particularly at the higher levels, to repeated head blows. Many patients I see, for example, have had 30 years in total of repeated head injuries.
Dr. Cohen, do you have anything you would like to add here?
Well, I agree. What we've heard from Dr. Mobbs is a lot of symptoms. And just to be clear, symptoms is something that the person will complain about. They're not something that you can necessarily demonstrate yourself. That's a physical sign. But we can't determine whether those symptoms are CTE. We can speculate. We can presume a patient's symptoms, what they're experiencing now, a history of having played, of having maybe had a concussion, or what, sometimes even if it's not a concussion, what's now called subconcussive or non-concussive brain injuries, can allow us to suspect this. But we can't know for sure. We can't open up somebody's brain whilst they are alive, take a slice and look at it under the microscope, as we could for, say, a skin lesion, and say, oh, that's definitely CTE. On your skin, you can say, yep, that's a melanoma. In your brain, you've got to wait until the person has died.
So you can't open up someone's brain and examine it while they're still alive?
They tend to object. As your friend might, but no.
Under a general anaesthetic, of course.
Yeah, certainly not during a sporting match where you've got to run onto the field and do that. It tends to hold up the game. So the only test we have for CTE is post-mortem. In other words, the person has to have passed away. And Let's be clear, not everybody has a post-mortem. Less than 1 in 100 people has a post-mortem. So despite the legal and the medical and the detective shows we see on TV, where everybody has one, less than 1 in 100 people have one. And even if you have a post-mortem, you don't necessarily have the full neurological examination unless they're specifically looking for something and the coroner directs them to. In which case they have to slice the brain up and do special stains and start to look at the tissue under the microscope. And obviously that can't be done while someone's alive. So we can't know for sure until after they're dead.
Well, Mr. Davison would prefer to resolve this claim while he is alive, obviously. So is there any other diagnosis that can be offered to him?
Well, certainly while someone's alive and we have a history of repeated head injury, we have a term which we call traumatic encephalopathy syndrome, or TES. And that's been used by health professionals to describe a clinical presentation of symptoms while the patient's still alive. And the symptoms that Mr. Davidson has displayed, as listed by Dr. Mobbs, coupled with a history of repeated head trauma, can lead one to, in the absence of anything else, suspect and diagnose traumatic encephalopathy syndrome, or TES.
And Dr. Mobbs, you would agree with that?
I would. So he has a unique profile consistent with TES. It's unlike any other dementia subtype, really. He has this anger dysregulation, emotional dysregulation of sudden 0 to 100 rage that he can't control. That's to little trigger, minimal trigger from others, say just somebody's left clothing on the floor. He has a continued decline pattern, and I note that his alcohol intake was really only the last 2 years at a daily excessive rate. He had plenty of binge drinking in his footy days on a weekend before that, but it seems that his 3-year decline preceded then the heavy alcohol. And I would see that as a self-medicating feature, which is common in TES. So he's got depression and anxiety. He's had emotional dysregulation and rage, and he's then drunk as a response to that, in my opinion.
Although you have also described most of the members of the bar present in the audience today.
Very fair.
Yes, it did sound familiar. Now, in this particular applicant's case, you've already touched on this, Dr. Mobbs, you have examined him and prepared reports?
Yeah, I have indeed, yes.
And Dr. Cohen?
Yes.
Given the applicant's reported symptoms and the history obtained on examination, does he display symptoms consistent with CTE?
Yes, he does. Would you like me to elaborate on that?
Yes, please do.
Okay. So he saw a colleague of mine, a male neurologist previously, who ran some tests, thought he had dementia. Those tests were consecutive MRI brain studies showing a shrinkage of his brain over time. There were an increased number of white matter changes, we say, and some areas actually of gliosis or scarring, which could be moderate traumatic brain injury, or a bit more than concussion. He then went on and had PET imaging, FDG PET showing low activity in the brain or low metabolism, consistent with dementia. And his consecutive neuropsychology tests from 3 years ago and then 1 year ago showed a decline in his cognitive functioning, particularly his ability to learn new information, and particularly his language cognition appears to be deteriorating far outside of his normal, actually very high baseline. From humble beginnings, this is a very bright chap who then went on to study economics, and he should be performing much better than he is.
Dr. Cohen, what are your thoughts on that?
I'm hung up on the words that Dr. Mobbs used, and yes, these are consistent with TES and consistent with what can later be seen to be CTE, but I wouldn't go as far as to diagnose. That's kind of specific when you actually label somebody with that, say this is what we are now deciding that you are suffering from and we're going to treat it. The patient, for instance, reports of depressive symptoms from at least adolescents, 17 years of age, and alcohol abuse and substance abuse. We really need to look and work out which of his current problems are due to the repeated head injuries or perhaps some mental health over time. And those mental health issues may superimpose themselves on this position of trauma as well. So yes, you can say that all of this might add up to TES now, but we simply cannot call it CTE because we can't say that because he's sitting there in front of us today.
With respect to Professor Cohen, the imaging did suggest a shrinkage and atrophy, a dementia picture that was really patchy and inconsistent with the global atrophy we see of, say, an alcohol-related dementia. Nor did he have the global cognitive impairment profile. It, again, was quite patchy and very severe in the registration and language domains, as I've mentioned. But I certainly take your point that there have been confounding factors here to tease out. On balance, I would interpret a dementia picture consistent with tests.
Sure. And I guess, without being overly argumentative here, referring to our very good friends from Monty Python, we are all different. And everybody's brain starts different, and everybody's brain develops different, and everybody's brain experiences different things during their life. And I don't think everybody that has an alcohol problem has exactly the same picture on CT and MRI or on a number of different tests. They're all suggestive, I agree. They are all consistent, I agree, but they're not diagnostic.
Although you'd accept that depression would not cause atrophy on imaging?
Oh, no, I think there's a whole lot of things at play here.
Okay.
Unfortunately, nobody has yet invented the retrospectoscope.
And I would say that if he has tests and CTE, he's a very vulnerable individual. To get it so young would be very unlucky. And perhaps there's a genetic factor there.
Certainly, we're all different.
It's very helpful.
Dr. Cohen, at the risk of creating my friend's case for him, what, in your opinion, would be a more likely diagnosis for Mr. Davison?
I think it's very difficult to plug any one diagnosis, and we hate labelling people. But no doubt he's very young and that he started to experience significant manifestations of abnormality as early as his adolescence in his 17s. By his mid-30s, he's got dementia-like symptoms. We don't want that in anybody that young. In fact, when it happens to someone in 80 or 90, we're prepared to put up with it. Anything younger than that, we start to think this is a pre-senile dementia. But what it does suggest is there may have been a form of neurological damage before he even started playing rugby or before he went to a higher level of his game. So I think there's a mixed picture here, and I think we can see a whole lot of symptoms, but unfortunately, for CTE, we've got to wait till we actually have an autopsy, and everything else will just be speculation prior to that. We can say he has a syndrome, which is just a description of those syndromes, and TES is just a fancy way of describing all those different elements, but we cannot be definitive.
So, in your opinion, the link between all those head knocks and his current symptoms, that's all just coincidence, is it?
No, not at all. I just think that we can't say that one leads to the other. We cannot be categorical about this thing. We don't know what else has been happening, and we don't know what else happens in somebody's life. And every time they fall off their bike, and every time they stack the skateboard, and every time they get dumped in the surf, and every time they smack their head on the door getting into the car, we don't add all those things together. What we do know is a history of playing sport and repeated head injuries that are associated with those sport, and we're very sorry that he's ended up in this position, but I don't think we can say that he has CTE yet, and I think, unfortunately, we're going to have to wait.
All right, so leaving aside whether it's CTE or TES, Dr. Mobbs, would you say that it's related to the rugby playing?
I would. I would say, he was completing a Bachelor of Economics. He was doing really well in life until the last 3 years where the decline has really set in. That decline has now been objectively matched with repeat neuropsychology testing to show these deficits worsening. So whatever reason this gentleman's in a picture of dementia, radiologically and clinically, it's hard to think of another cause outside of his repeated head injuries, plus he has the classic features of TES. And there are players reported this young. The youngest internationally reported in the neuropathology studies has been age 17 for CTE. So the pathology can start very young. In this player, it appears to be consistent. I don't see a primary psychiatric disorder of just depression, just anxiety, nor an alcohol-related dementia picture confounding. I think he has self-drinking, self-medicating alcohol use disorder, and I think he's otherwise got a very classic dementia picture.
And bearing in mind also, Dr. Mobbs, I think you commented in your report about the frequency with which Mr. Davison played and trained.
Yes, so his burden of repetitive head injury was mainly in training. So he played 3 or 4 times a week in training, and he had a lot of contact exposure during that. He played only 1 game on a weekend typically. He was very humble this morning, I think, just hearing those comments, but he told me he was a star player, very targeted, and having a lot of tackling and a lot of head injuries through that. So that repeated exposure would be far in excess of the amount needed to trigger CTE.
And those head knocks in contact sports like rugby, they're unavoidable, aren't they?
Yeah, it's part of tackling, tackle after tackle, head hitting another player or head hitting the ground. And he seemed to, in terms of pure concussions, so they are symptoms after a head injury, associated with head injury, he didn't seem to understand that it wasn't just a knockout. It could be other symptoms like ataxia, that's his wobbliness on his legs, slowness, confusion, stars, dizzy, all manner of spectrum of neurological dysfunction after head injury.
So you're referring to both the concussive load and the subconcussive load, is that right?
Yes, so the main risk for this gentleman to have CTE is his subconcussive load or subclinical traumatic brain injury burden versus the concussions, but the concussions don't help. And as I've suggested from his MRI brain, it does suggest he at least has had 1 moderate traumatic brain injury mixed into the picture here. But that would be not enough to correlate to his current clinical state. His current clinical state represents a dementia process that's far in excess of a single moderate head injury, in my opinion.
And Dr. Cohen, what's your opinion on that?
It's troubling, if a tree falls in the forest and nobody sees or hears it, does it actually count? And this is, I think, the struggle we've got with this subconcussive or non-concussive argument. What it suggests to you is that there weren't enough obvious signs to the people who were there with the level of knowledge to say, aha, that's concussion. So we'll just assume that there's been lots of them and then we'll say they're all subconcussive. And that's very difficult. What we really need is to measure these things and to have people who are experienced and skilled and trained from a very early age, at school level, at training and at games, so that we actually start getting some statistics. At the moment, all we've got is this repeated pattern of, I think that's what's been going on. And he said he was knocked out, but that's what he was defined, told being knocked out was concussion and everything else didn't count. So there's still so much confusion here. And part of the job has to be to educate the public, the players, the parents, the school, to understand that it's not just being knocked out, to understand that any time you suffer a blow to the body as well as to the head and end up feeling differently or are observed to act differently, then that really has to put one in the subconcussive or non-concussive or even concussive column. We have to identify these things as there. Everybody thinks it's a giant satellite in the sky with a television camera aiming down there and the government is collecting the statistics on that. We're not. And we need to, if we want to get an answer, and to understand the depth and breadth and scope of this entire problem.
Thank you, Ron. I've got no further questions. Is there anything else I can assist you on with at this stage?
No, that's extremely helpful, and thank you for taking each of the experts to those questions. I'm obliged. Thank you. I would like to hear from Mr. Connell and see if he has any questions for them. Thank you. Dr. Cohen and Dr. Mobbs, Mr. Connell will now ask you some questions. He's representing the university.
Just a few questions. That's been a very helpful discussion so far. So my understanding, please correct me, Dr. Cohen, Dr. Mobbs, if I'm incorrect, that in terms of terminology, there seems to be a consensus of views that CTE is a diagnosis that can be only definitively given post-mortem, when a sample can be taken from the brain. TES is the descriptor of a constellation of symptoms consistent with CTE, and it's the name that's given when you can't definitively diagnose it. So TES is, we're speculating that it seems likely it's consistent, and that's the name we give it. So by definition, you can't diagnose CTE definitively until after the person is dead. Is that a fair summary?
That's correct. I think it's very much the same as Alzheimer's disease. You cannot diagnose it definitively. until after death at autopsy.
And so just then taking up Alzheimer's disease, can I ask you, Dr. Mobbs, why would you exclude that as a diagnosis in this case?
Alzheimer's disease is a very easy diagnosis to make. I'm sure Professor Cohen would agree with me. They have very key characteristics in the clinic, both on the history they provide, the complete loss of insight versus partial loss of insight that CTE displays. They have memory loss across the board. They cannot learn, they cannot recall even learnt information, or long-term memory eventually goes. And they have key physical characteristics. They have key characteristics on imaging with shrinkage of the hippocampi, precuneus, other regions. It's very easy to spot on MRI and PET scan along with the clinical picture. And it's typically an age-related dementia. So by the time someone's 70, for example, they have a 10% chance, 5 to 10% chance of Alzheimer's disease.
So Dr. Cohen, would you exclude Alzheimer's in this case?
Oh, look, I think these things can both be occurring together. And I think we're just in the realm of speculation here, and you can't tell. And whilst we see pictures on X-ray and CT, MRI, all these expensive technologies, they are strongly suggestive and associated with, but every now and then even we doctors get surprised when we actually have a look at the tissue under the microscope.
That's true.
Can I ask you both then about the prevalence of CTE, and firstly in the general community, and noting your comment, Dr. Cohen, that only 1 in 100 cases have a post-mortem, and even less have a neurological test of post-mortem. What is the prevalence in the general community? And then, sorry, double-barreled question, but then compared with the prevalence in traumatic injury in sporting contact sports is what I'm trying to say.
There's a secret to answering medical questions, and that is that the initial response is that depends to almost every question you're asked.
You've been too well coached,
We don't
Dr.
really
Cohen.
know that. To get an accurate prevalence, you have to have large numbers of people who've been studied and with good information and with good consistent data. Because so few people have an autopsy at all, let alone a neurological autopsy, and because we are struggling to get people to donate their brain to the Australian Sports Brain Bank who don't have a reason to do so, in other words, because they are affected the problem, we really can't truly give a prevalence. What we do know, though, is that people who have played combat or contact sport compared to people who have not have between 5 and 10 times greater potential to be diagnosed with CTE post-mortem. We need people to donate their brains. It's a challenge I throw out to the members of our audience here today, even if you've never played these sports, because we need to have something to compare.
Dr. Mobbs, is that your view as well?
Yes, and indeed there are being a relatively newly researched field in football as opposed to boxing, and we still have relatively lower numbers if you think epidemiologically and if you think about larger neuropathology studies. But perhaps in, say, the NFL, it might be around 10% of their top cohort who have CT, maybe.
And just drilling down a bit further, is there any comparison between the different codes, NRL, AFL, soccer?
No as yet, because we need more numbers in the research to truly compare code to code, but it is reasonable to say that a hard tackle is a hard tackle, and you could approximate across the tackling football codes, I would reason.
Sure. We've researched and looked at the number and the force involved in tackles in rugby league, rugby union, AFL and NFL. By and large, the numbers are not that different. What is interesting is the way that force is applied. So, for instance, an AFL player usually isn't lined up facing their opponent and tackling or avoiding being tackled head on. And then, of course, we've got a good friend playing the round ball game, where heading the ball is encouraged and to score or to defend. And to get good at that, you're supposed to practice it tens of thousands of times to get it right. So there is the commonality of repeated energy being transferred to the brain in all of these sports. And I don't think we can say that one is necessarily worse than the other. If we look at our combat sports, it's very different because the very aim of those activities is to create a brain injury, and that's how you win.
What about boxing? Is there better?
I put in the combat sports category. So the aim of boxing is to knock your opponent out. In other words, to inflict a traumatic brain injury such that they cannot stand up unaided. There's no doubt that, and in fact, the CTE picture diagnosis wasn't made 10 years ago when we first had a class action in the NFL. The first recorded incidents go back to the 1880s. And people were then identified whether they were pugilists at the time or whether they played contact sport at the time. It started to be examined and to see that they had long-term problems. They often got sent to an asylum. And it wasn't until 1928 that it came into popular parlance to start calling these dementia pugilistica, but it was also identified not just in those fighters, because they often were the same people who played contact sports as opposed to combat sports.
Yeah, and indeed, Professor Cohen, my youngest, more severe patients are boxers.
Yeah.
Indeed.
And that sounds about right. Could you please perhaps shed some light on the history of the development of public awareness and consciousness amongst the football codes in particular, compared to, the knowledge of pugilistic dementia I think you described in boxing? When did the football codes become aware of this corresponding risk?
Well, the Australian guidelines were largely evolved in 93, 94, actually, by the NHMRC, as far as mainly for concussion, but also neck injuries as well. So they looked at preventing neck fractures and spinal injuries. Concussion was recognised that it could be repetitive, and with that repetition, there may be longer-lasting neurological troubles. It wasn't until 2005 that Benna Omalu, a neuropathologist in the US, identified the first case of CTE in an NFL player, deceased. And then the Boston University team had more and more cases come through to now I think over 700 brains with CTE demonstrated. And you've heard about the class actions as well.
Just moving on to a topic of causation. It's maybe impossible to answer, but is it possible to give with any confidence a view about the relative significance or potency of, we know this man's had concussion since he was 9, over a long period. Is it possible to say what's more significant? Is it the first injury? Is it the last injury? Can you perhaps help us with that question?
I don't believe it's possible to be exact on what damage every injury causes. We don't have a biomarker of concussion, after all, to demonstrate inflammation in the brain. But we do have data on positions from NFL, so linebackers, linemen, linewomen are more at risk of repeated head injury, and the longer you play as a proxy for subclinical concussive events, the higher your risk of CTE, the earlier you manifest and the more severe. Professor Cohen, would you like to add to that?
I just hark back to that old smoking ad we've all seen. Every cigarette's doing you damage, every blow to the head's doing you damage. The more you have, the more you get, the more likely you are to get more, because the less able you are to protect yourself as well. So if we want to do anything about this disease, we have to decrease the total number of injuries you have over your life.
And just relating to that, the marker of CTE being this protein tau, which you can only find. Is there any way of testing for tau apart from the postmortem?
It's not as simple as tau.
Blood test or scan or anything like that? No?
A particular form of tau, it's in tangles, it's a structural protein, and you see it when at the specific areas of the brain under the microscope and around the blood vessels, as we've heard before. But tau levels in the blood and tau levels even in the cerebrospinal fluid, the fluid that surrounds the brain, are not able to be used to diagnose whether there's actually been an injury.
No, that's under research. So yes, we can't be 100% sure that's true during life. There's no test for tau for this particular dementia.
And in terms of the pathology, how does the build-up progress? Is it just a slow, degenerative, progressive build-up of tau over time? So, for example, if the 9-year-old Mr. Davison we were capable of testing for tau following his first concussion, is it likely that there would have been some evidence then that progressively developed with further concussion?
It's not possible to know in Jimmy, Mr. Davison, when a tau deposition and process beginning for dementia might have occurred. We know that CTE, like almost all dementias, is a very slow process over years. As I mentioned, the 5-year threshold, 2 years at the highest level to trigger off CTE, but we don't have a marker, so we don't know when that occurs in players.
Right. Thank you, Your Honour. I have no further questions.
Thank you, Mr. Connell, and thank you, Dr. Cohen and Dr. Mobbs, for your two differing but very helpful views on particularly on diagnosis, which I must say I found very helpful. Now, in a slightly unusual break from the norm, I'm going to ask Council to sum up. Is that right? And ask you for. Well, that's not the break from the norm, but because of the time, I'm going to give you 2 minutes each, no more. Normally, barristers would have as long as they want, generally, to bring it all together. But Mr. Connell, are you in a position to? I'm particularly interested, I might say, in your application for summary dismissal. And while I've obviously followed the thread of everything and have a very good handle on where you're coming from, could you sum that up for us, please?
Well, I think we've got a definitive answer from the medical witnesses that. As I understand it, you can speculate, but you can't definitively say that you can't make a definitive diagnosis of CTE. So my application is based upon that simple proposition that we've heard from the medical witnesses that whilst they have different views and they speculate slightly differently, they both seem to agree, on my understanding, that definitive diagnosis is not possible, and that's the basis for my application.
And your position, Mr. Connell, is it not, is that there simply must be no possible prospect of the claim succeeding?
That is the CTE claim.
Yes. Yeah, I understand. Thank you.
Thank you.
Ms. Bosman.
Thank you, Your Honour. In my submission, there is certainly the prospect of the claim succeeding, if not in relation to CTE, then in relation to TES, and that is ultimately an issue for the trial judge. In my submission, it is not up to this jury to decide on the basis of the very brief evidence they've heard today, and it cannot be said that my client's claim has absolutely no prospect of success. Can I just touch for 30 seconds of my 2 minutes on my friend's suggestion that causation may be related to prior rugby games and pick up on the point that Dr. Cohen made that every cigarette is doing you damage. In Australia, that's been recognised by the High Court in cases such as Amica and Booth, which dealt with dust diseases and asbestos claims, where it's impossible for an applicant to prove how much exposure to asbestos might have given them mesothelioma, for example. And the way that the law gets around that is to recognise that in certain situations where science and medicine, such as in the case of CTE, is still developing, the law will get around that by recognising that if there's been a material contribution from the university playing, then that is sufficient for my client to succeed.
Thank you.
Very briefly, just in my last 1 minute, touching on my application to strike out the paragraphs with respect to the waivers and the protocols and the medics. Mr. Davison gave evidence that he couldn't recall ever signing a waiver. He gave some evidence that a medic might have attended him, but he's very confused, Your Honour, so he might have been misremembering that. I also just wanted to touch on the fact that my friend Mr. Connell has filed a defence, and at the end of the defence, as Your Honour would be aware, lawyers must certify that as the filing lawyer, this pleading is filed in accordance with the instructions of the parties for whom I act, but that's not the be-all and end-all, Your Honour. There's another paragraph that says there is a proper basis for each allegation of fact in the pleading, and it complies with the rules of court. And in my submission, Your Honour, that means Mr Connell has an obligation as an officer of this court to file pleadings, not just on the basis of being a mouthpiece for his client, but as an officer of the court, matters that have a proper evidentiary basis.
Well, I think that's absolutely right. Mr Connell is one of the founding partners of Gilchrist Connell, a firm of impeccable. So there can't possibly be any suggestion that there's a problem there.
Thank you, Your Honour.
Thank you.
Yes, well, I'm indebted to my learned friend for that salutary reminder of my ethical obligations, but I do have instructions that there was a protocol and it was signed, and we'll find a witness by the time this case is finished, I assure you, Your Honour.
I'm grateful, Mr Connell and Ms Bosboom, you've both been very helpful today. And then at this point, I would usually make my finding. Do you want me to make one or move on to those questions first?
Judgment's reserved, I think.
Yeah, I'm going to reserve judgment on this very difficult issue. I'm extremely grateful to counsel for giving up their time today on both parties to make a very unusual step of actually having counsel appear without a charge. So we should all appreciate that. Thank you. I don't do it for the money. I've got a pension coming at some point, as I understand. But also to Dr. Cohen and Dr. Mobbs, because as I'm sure everyone here recognises, these two are not pretending. They are absolute experts in their field, and for them to give their time for us, we're extremely grateful. I will reserve judgment, but we would also take the unusual step of throwing questions open to the entire floor. This does not happen in a courtroom. And Dan's got a mic, and there are a few roving mics. So you're very welcome to ask questions of anybody, of any of us, and we'll see what we come up with.
We do have a question from the floor. Whilst the past cannot be changed, what can a university do to manage its exposure going forward?
Very good. Dan, you can
Well,
take that.
are we looking from a legal perspective of what a lawyer can do, or do we want to hear from the experts in the sense of what procedures they believe can be implemented, before?
Why don't we start with the experts and so medical, and then we can give some comments from the legal side. Adrian, Rowena, any views?
Yeah, very much. Firstly, awareness comes key. So instead of just the lip service that we take this, very seriously, and player safety comes number one, you've got to walk that walk instead of just talking it, which means you've got to have proper facilities there. You've got to look at these injuries that happen. You've got to educate everybody who's involved with them as to the seriousness of them. And you've got to start there not just at the university team level, but right down at the school level as well. So that you take it as seriously for young players as you do for older ones, that even if mum and dad want the kid to play for Australia one day, the fact that somebody expects they've had an injury needs to come off, it's worthwhile doing exactly that. So we've got to have rules. We've got to enforce the rules. We've got to not make exceptions because they're a brilliant player or because the team's in trouble or because their friends are relying on them. We've actually got to realise that this is a significant issue and make sure that we don't exacerbate the problem through our ignorance or through our inattention.
And I would say it's very hard for a 21-year-old entering football to understand dementia or know its risk. Of course, that system will always be imperfect, even if we talked about dementia, but as yet we don't have protocols or warnings or anything talking about dementia, it strikes me. We've got a lot on concussion, but as yet we haven't seen the codes talk about CTE or talk about dementia prevention. No one wants to use that word. It, can be alarmist in some people's eyes, not intended for us to be alarmist. But I think that AIS protocols need to then build to further discuss the future potential for dementia in a player, and that needs to be recognised in some processes in a regulatory form, I would imagine.
Fantastic, thank you.
I might just add to that in terms of the legal position. I think it's sometimes said that whilst science and medicine race ahead, the law often limps slowly behind, but I think the obligation, particularly if you're a university, is to make sure you keep abreast of the science and best practice and protocols, and make sure that they are they're conformed with and followed. And if you're an organisation with resources such as a university, probably a higher standard's going to be expected of you than perhaps the junior football club at North Parramatta, where they don't have the resources necessarily to have all of the systems in place. But if you're a university and you haven't conformed, then I guess you're a slow-moving target for the lawyers and the class actions in future years if you haven't met the standards expected.
And I just add to that, which I think the question was driving at as well, is to ensure it's appropriately documented. So it's one thing, quite right, the past is the past, but be aware of what the protocols are in place, and when things, make sure they're documented, make sure they're adhered to, as Adrian and Rowena said, and then document it as well, because as we heard today, down the track, people say all sorts of things were signed and no one can find the paperwork.
Dan, if I can maybe ask the last question. I'm curious because the rugby club, the backpackers in this situation, they're not necessarily part of the university. They might have the university brand, but they are a separate affiliation, whether they're a legal entity in their own right or various other things. So I'm curious, that's probably true for many of the organisations in here. And I'm assuming that when something goes wrong, there'll be a shotgun approach. They'll go for the club, they'll go for the university and various other things. I'm just curious, what's the nexus? How we don't run the rugby games, we don't do the training sessions as a university. So what should we be doing, or are we protected because of that?
It's going to be heavily fact dependent. So it's very difficult to sort of sit here and say, well, these are the things that are going to make the association liable versus the university. I mean, in the type of situation you're alluding to, you would think that the association is obviously far more in the gun than the university. But the reality is, I think particularly when you're looking at claims where they do rope everybody in, and particularly if they're in class actions, there's significant exposures even if you have a strong defence on a point like we didn't owe a duty because of the precise legal relationship between us and the plaintiffs or the class. You can have these claims that are class actions that the headline figures are very significant and the costs to defend them are very significant. So there are exposures that will arise even if you might have very good defences available because of the way that the club or the rugby union side is structured as compared to the university. I don't know if Steve or Audrey had any comment on that.
Only that I'm glad you asked the question, because that's why I objected to Mr. Davison's evidence about the affiliation between him speculating. But I must say I had assumed, I don't know what the facts are in this case, but I assumed that the backpackers fell within the umbrella of the Unimutual policy that covered the university and all of its affiliates. And I may be wrong about that, but as you say, it's hard to pin responsibility back to the university when it's really just a rugby club, not much different to any of the other suburban rugby clubs in terms of its organisation and structure and the way they operate, I assume.
The other related point there, which I think there is plenty of law on and history on, is that where you see repeated exposure like this, and a couple of people have mentioned asbestos and mesothelioma and other such related, and you could have someone that would work for one company for 30 years of their 34 years of their 35-year career and work somewhere else for 1 year, and when it came to the claim or the class action, both were on the hook equally. So there's often not sort of passing of liability there. It's just exposure can lead to liability. Once you get that connection, which in this case you may well get post-mortem, with the clear evidence of CTE post-mortem, unfortunately, not while Mr. Davison's still alive, and that can lead to a short period of exposure leading to actually significant financial exposure.